Can my employer fire me for refusing to work overtime? Imagine this. Your boss asks you to stay late after an already long 8-hour shift. You're tired, you've got family waiting at home, and you say, "Sorry, I can't work overtime tonight." The next day, your name disappears from the schedule. Or worse, you're told you're fired. That raises the question, can your employer legally fire you for refusing to work overtime? For millions of hourly workers in retail, food service, healthcare, manufacturing, and more, this isn't a hypothetical. Employers often demand extra hours, sometimes on short notice, and workers need to know their rights. In this video, we'll break it all down. What the Fair Labor Standards Act, FLSA, it says about overtime, whether employers can require it, situations where refusing overtime is protected, state-level differences, real-world cases, and what steps you can take if you're threatened with termination over overtime. The FLSA and overtime basics. The Fair Labor Standards Act, FLSA, is the federal law that governs minimum wage and overtime. It says that most non-exempt employees must be paid time and a half for hours worked beyond 40 in a workweek. But here's the surprise for many workers. The FLSA does not limit how many hours an employer can require. It only ensures proper pay. That means employers can legally require overtime. Refusing to work overtime can be treated like refusing any other work assignment. Employers may discipline or even terminate employees who refuse, as long as the decision is not discriminatory or retaliatory. Example: a warehouse requires mandatory overtime on weekends. If a worker refuses, the employer can fire them, as long as overtime pay rules are followed. So under federal law, yes, you can be fired for refusing overtime, unless another protection applies. Exceptions. When refusing overtime may be protected. There are important exceptions where refusing overtime is legally protected. 1. Safety concerns, OSHA. Under the Occupational Safety and Health Act, OSHA, workers have the right to refuse work that poses an imminent danger of serious injury or death. Example: a truck driver asked to work a double shift past federal driving limits can refuse for safety reasons. 2. Americans with Disabilities Act, ADA. If a medical condition or disability limits hours, workers may request accommodations. Saying, example: a nurse with a chronic illness provides medical documentation limiting her to 8-hour shifts. Terminating her for refusing overtime may violate the ADA 3. Family and Medical Leave Act, FMLA. Employees covered by the FMLA can refuse overtime if medically necessary for their own condition or to care for family. 4. Union contracts and collective bargaining agreements. Many contracts restrict mandatory overtime or require extra pay beyond the FLSA standard. Example: a factory union contract caps overtime at 12 hours per week. Firing a worker who refuses beyond that may breach the contract. State laws, stronger worker protections. Some states go further than federal law in limiting forced overtime. California requires daily overtime after 8 hours and double time after 12 hours. While employers can require overtime, state law strongly protects rest breaks and daily caps. New York, healthcare workers are protected by the mandatory overtime for nurses law, limiting when hospitals can force overtime. Massachusetts protects certain public safety employees from forced overtime. Oregon and Washington regulate mandatory overtime in healthcare and other safety-sensitive fields. Example: in New York, a nurse cannot be fired for refusing overtime except in emergencies, thanks to state law. Discrimination and retaliation concerns. Even if overtime is generally mandatory, employers cannot enforce it in discriminatory or retaliatory ways. Discrimination. If overtime requirements are imposed only on women, older workers, or employees of a particular race, that may violate Title VII or the ADEA. GEM retaliation. If an employee refuses unsafe overtime or files a complaint about wage theft, firing them could be unlawful retaliation. Whistleblower protections. Employees who report illegal or unsafe practices cannot legally be punished for refusing related overtime. Example: a worker who complains to HR about unpaid overtime and is then fired for refusing another overtime shift may have a retaliation claim. Real-world cases. Case 1. A hospital in New York disciplined nurses for refusing extra shifts. The state ruled the discipline illegal because healthcare workers are protected from mandatory overtime outside emergencies. Case 2. A factory worker in California was fired for refusing a 14-hour shift. The court found the employer violated daily overtime and rest break rules. Case 3. In a federal trucking case, a driver refused overtime because it would have violated Department of Transportation limits. The refusal was protected under OSHA safety rules. Case 4. A retail worker refused overtime after filing a wage complaint. When fired, the NLRB ruled it retaliation, awarding back pay. These cases show that while mandatory overtime is often legal, firings tied to protected rights can be challenged successfully. Impact on work-life balance and benefits. Overtime isn't just about pay. It affects family life, health, and benefits. Health. Long hours increase risks of fatigue and accidents. Family obligations. Parents may struggle with childcare if forced into overtime. Benefits eligibility. Working more hours can affect health coverage, retirement contributions, and leave balances. Isolation and burnout. High turnover often follows when employers abuse mandatory overtime. This tension between employer needs and worker well-being is one reason states are adding restrictions. What workers can do. If you're facing mandatory overtime, 1. Check your classification. Non-exempt workers must be paid overtime. Exempt workers often aren't eligible for overtime pay. 2. Review state laws. Protections differ widely. Healthcare, trucking, and public safety often have special rules. 3. Look at contracts. Union agreements may restrict overtime. 4. Document everything. Keep records of hours, requests, and reasons for refusal. 5. Know your rights. If refusal is based on safety, health, or discrimination, you may be protected. 6. Seek legal advice. If you're fired after refusing overtime, a labor attorney can assess claims. Example: a janitor fired for refusing overtime after a 14-hour day keeps documentation and files a wage complaint. The Department of Labor investigates, finding the employer violated rest laws. The bigger picture. Overtime law highlights the balance between employer flexibility and worker protection. The FLSA guarantees higher pay for extra hours, but leaves most scheduling power with employers. States and unions are stepping in to close gaps, especially in industries where fatigue threatens safety. The key is understanding when refusal is simply insubordination, and when it's a protected right. Without knowledge, workers may assume they have no choice. With knowledge, they can push back when employers cross legal lines. So, can your employer fire you for refusing to work overtime? Under federal law, yes, because the FLSA regulates pay, not scheduling. Employers can generally require overtime, and refusing may lead to termination, but the full answer depends on context. If overtime is unsafe, medically impossible, violates union contracts, or breaches state laws, refusing may be legally protected. And if firing is tied to discrimination or retaliation, it's unlawful. The bottom line: overtime is often mandatory, but workers still have rights. Know your state's rules, keep records, and speak up if demands cross the line. If this video clarified your rights, share it with coworkers. The more workers understand overtime law, the harder it is for employers to misuse it.